Good afternoon. I'm Nina Peckman. I'm a staff attorney at Advocates for Children of New Jersey, and today I'm going to talk about school discipline in New Jersey. ACNJ is the trusted independent voice, putting children's needs first for more than 40 years. We educate the public and policymakers and equip caregivers with the information they need to be their child's strongest ally. Our work results in better laws and policies, more effective funding, and stronger services for children and families. This means more children are given the chance to grow up safe, healthy, and educated. The Kid Law Resource Center provides information and assistance to parents and those working with families about laws and legal processes affecting children, including education and child welfare laws. You can learn more about us at www.acnj.org. Now, this presentation is intended to provide information and does not constitute legal advice. Discipline laws are complicated, and consultation with a lawyer or education advocate is highly recommended regarding individual cases. For assistance, you can contact me, Nina Peckman, at ACNJ. In this presentation, we're going to cover the rules and procedures that schools must follow regarding suspensions and expulsions, student and parent rights when students are excluded from school, how to appeal an administrator's or Board of Education's decision, and we also include various resources for further information. School districts, including charter schools, must have a written code of conduct that comply with New Jersey education laws, which is usually found in the student handbook. This handbook should be distributed yearly to school staff, parents, and students. It's often available through the school website, and if not, the Board of Education has to provide it upon request. School District Board of Education must also develop written policies regarding discipline rules and procedures that comply with New Jersey education laws. Again, these are often found on the school website under the subject Board of Education, and the Board of Education must provide these upon request if you don't find them on the website. Students can be suspended or expelled for a variety of offenses, including disobedience, defiance, physical assault, theft, property damage, possession, using, or being under the influence of drugs or alcohol on school grounds, harassment, intimidation, or bullying, to name a few. A parent and student should review the school's code of conduct to become familiar with the rules and potential consequences of rule violations. When a student violates a district's code of conduct, the school administrator may impose consequences, including denying participation in extracurricular activities, denying privileges, access to school functions, sports, and graduation ceremonies. A student can be removed from the classroom or receive a detention. A school can require an in-school or out-of-school suspension, and expulsions can be imposed in extreme circumstances. However, prior to suspension and other school exclusions, a school administrator is supposed to consider alternatives, such as positive supports and interventions, requiring the student to write a written reflection or apology, imposing a loss of a privilege at home or in school, community service. The school staff can schedule a meeting with the parent and student to go over the conduct issues and possible solutions. A behavior contract can be written that the student signs and is held to complying with. Counseling and or mentoring services can be provided, or referrals to community-based organizations may be appropriate. There are also certain limitations on suspensions. Aside from the requirement that districts consider alternatives and implement positive behavior supports. So preschoolers and students up to second grade cannot be suspended. unless the conduct relates to a violent or sexual nature that endangers others. In addition, alternatives to suspension should be imposed for minor behavior infractions. Also, students should not be suspended for things like absences or tardiness. And finally, special considerations apply for students with disabilities, which could violate a student's rights if the student were to be suspended. Schools are mandated to implement early detection and prevention programs. These are programs to identify students in preschool through second grade who are experiencing behavior or disciplinary problems. When a need is identified, support should be provided, and if appropriate, interventions should be based upon formal evaluations. There are certain exclusions that could possibly violate a student's rights if these exclusions are done without the formal suspension process, especially if the intention is to discipline the student and the staff don't follow those appropriate processes. For example, sending a student out of the class frequently, or frequently asking the parent to pick up the student from school when the school gives the reason that they can't manage certain behaviors. And although school staff can deny participation in a school activity or deny a privilege, if negative consequences are frequent occurrences, it might be that the school is not using appropriate behavior tools or not following the discipline rules or not giving appropriate education supports to the student. As mentioned before, there are many rules regarding discipline. A short-term suspension is a suspension that can last up to 10 days, so no more than 9 days. Parents must receive oral or written notice before the end of the school day in the language that they understand. And the notice has to include what the specific charges are, which student code of conduct was violated, what are the underlying facts, the length and any conditions of the suspension, and a description of the appeal processes. Before the suspension, the student must be allowed to present the student's version of the facts at an informal meeting with the school administrator. This would usually be the vice principal or the principal. In addition, prior to the suspension, this is an opportunity for the parent to suggest alternatives to the suspension. A long-term suspension is one that lasts for 10 or more days. The rules in this case are that before the suspension, the student must be told what the charges are, and again has to have an informal meeting with the school administrator to get to explain the student's perspective of what occurred. The parent must receive notice before the end of the school day that the incident occurred and must receive written notice within 2 days in a language they understand. This notice must include a description of the specific charge, which student code of conduct was violated. Again, a description of the underlying facts, the length and any conditions of the suspension. And the notice must also include a description of the right to a board hearing and that the parent is entitled to bring an attorney to the board hearing, to bring witnesses and to cross-examine the school's witnesses, as well as the parent has the right to receive a list of witnesses and their statements no later than 5 days prior to the hearing, and also to request a recording of the hearing. An expulsion means that the student will no longer be educated in the current public school setting. This is a consequence that can only be used in extreme circumstances. The Board of Education can expel a general education student as long as all the procedural due process rights were provided to the student. So the same rules that applies to a long-term suspension applies in the expulsion, in the proposed expulsion. And the student is entitled to an informal and a board of education hearing. The student must be provided with appropriate education programs or services in an alternative education program in or out of the public school. However, for a second expellable offense, education services may be discontinued, meaning that the public school will no longer pay for the student's education, but only if the district proves that this is the only way to achieve school safety and order. And this is a difficult burden for the school to establish. The decision to expel can be appealed to the Commissioner of Education within 90 days. And finally, it's very important to remember that a student with a disability can only be expelled from his current program. That means that the student still retains the right to a public school education until the age of 21. Students can also be disciplined for their conduct away from school, but only if reasonably necessary for the physical or emotional safety and security and well-being of the student, other students, or staff on school grounds. And the conduct is found to materially and substantially interfere with the orderly operation of the school. Examples of when conduct away from school grounds might be grounds for suspension could be social media postings that affect the school climate or endangers another student in school, or if a student was charged by law enforcement with possession of an illegal drug with intent to distribute. On the other hand, off-campus conduct that is completely unrelated to school safety would not appropriately lead to a suspension, such as perhaps a physical fight at a weekend party between friends, or when student conduct outside of school, such as vandalism or loitering, leads to involvement of law enforcement. Again, these cases are very fact-specific. The laws and procedures and rights are very complicated. In all cases, I would suggest that a parent speak to an education attorney. They can contact me as well for assistance. So when it comes to students with disabilities in general, all students who have an IEP must still comply with their school's code of conduct. Students with disabilities have the same procedural rights as general education students, plus these other rights. That an administrator consider the student's unique circumstances to decide whether to require suspension or change a placement. And if the individual education program or IEP excuses a student from certain school rules and explains how negative consequences will be imposed, that these provisions be followed. While students with disabilities can receive a short-term suspension under certain circumstances, when a student receives a series of short-term suspensions equaling 10 or more school days, and when it is determined that the suspensions are related or indicate a pattern of behavior because of similar behaviors, the closeness in time between suspensions and possibly the duration of each, additional discipline rules apply. So for example, if the student had 4 separate 3-day suspensions between September and December, and let's say each was for a verbal altercation or confrontation with the teacher, and the student has a disability related to how the student expresses him or herself when upset or angry. Given this scenario, the student was suspended for a total of 12 days and for related concerns having to do with the student's disability. In this case, in this scenario, certain rules would apply requiring a review of the suspensions and the student's learning and issues and program. If the student is in special education, or if the student is not in special education, consideration should be given whether, given what's been going on, whether the student should be evaluated for special education. To be clear, if the short-term suspension is not related to the student's disability or can't be connected to each other, then the suspensions may have been appropriate. This process of reviewing the conduct and of how it all relates to the student's disability is known as a manifestation determination. And when the student's conduct is determined not to be a manifestation of the student's disability, a long-term suspension is a possible outcome. So here's a little bit more about the manifestation determination process. In this process, a child study team must have a meeting with the parent within 10 school days of a long-term suspension, whether consecutive suspension days or are proposed or following a series of short-term suspensions that are considered like a long-term suspension, to determine was the conduct caused or related to the student's disability. Part of this analysis includes reviewing whether the school staff developed and implemented an appropriate IEP for the student that would help the student reach behavior goals and help prevent violations of the student code of conduct. If after this analysis, the conduct is found to be unrelated to the student's disability, the student can be suspended for more than 10 days. If, however, the conduct can be related to the student's disability or an IEP issue, the student must return to school immediately. There's one exception to this rule. It's known as the 45-day rule, which I'll describe in the next slide. One more thing to note is that sometimes the child study team may have to conduct evaluations before being able to make an appropriate manifestation determination to see if the conduct was related to the child's disability. So this could include a complete reevaluation, in addition to psychiatric evaluation, and a functional behavioral assessment to find out the causes of the student's behavior problems and help the school develop a behavior modification plan, as well as other appropriate learning supportive plans. So the 45-day exception refers to a situation where a student with an IEP can be placed in an alternative education setting for up to 45 days, even if the behavior is a manifestation of the student's disability. In these very limited circumstances, when the incident involves possession of a weapon, knowing possession or use of illicit drugs, or infliction of serious bodily injury upon another person. Students who are suspended or excluded from school have certain rights to instruction and other protections. Exclusions or suspension days are not absences. Students have the right to make up classwork, homework, and tests. And within 5 days of being excluded from school, students must receive at least 10 hours a week of home instruction in schools, such as in the school building or at a board of education, in a public library, or at home, as long as there is an adult in the home. Instruction usually must occur after the school day, since the instruction is provided by school staff. And instruction must be provided on at least 3 separate days, plus the student must receive 10 hours of what's known as guided instruction, which could be providing the student with an audio or visual link to the classroom or projects to do at home with some teacher support. Also, the student has the right to be taught by certified teachers, the standard curriculum, and in-person or virtual instruction is permissible. However, if a student can only learn through in-person learning and the school district only offers virtual instruction, this isn't appropriate, and the parents should try to advocate for in-person instruction. Finally, a student's IEP or 504 plan must be complied with. So for example, if a student needs speech or occupational therapy to learn in school, or needs curriculum to be modified in order to learn, these should be included as part of the home instruction. Anytime a school administrator decides that a student needs to go to an alternative placement because of the student's conduct in school, the placement decision should be based upon an assessment of the student's risk for failure in the public school setting. This consideration should include the student's academic, health and behavior needs, information from the school's multidisciplinary team, or child study team if applicable, and notice to and consultation with the parent is required. A student can be provided with an in-district program, which is sometimes a program after the school day in the same school building, or a full-day program in a separate building within the district, or perhaps a program in another public school or a private school setting. Some parents opt for a full-time virtual instruction when they disagree that any of the proposed alternative placements are appropriate. However, a parent can try to advocate for an appropriate alternative placement that the school hasn't suggested, since virtual instruction at home violates the student's right to be with peers and exposure to all aspects of curriculum and school activities. The return to the school student's public school should be reviewed annually by the Board of Education, and transition services should be provided when the student returns. I talked about general education students and students who have an IEP, but what about a student who doesn't have an IEP as yet, but the parents and or school staff believe that the student might be eligible for special education? So a student with a history of behavior challenges or suspensions that are affecting the student in school may be eligible for a child study team evaluation to determine if the student needs an IEP. In this case, while the child study team has an obligation to invite the parent to a meeting to discuss evaluations, parents don't have to wait for that invitation. The parents can at any time request child study team evaluations, but to do so, they must write to the child study team to request a child study team meeting to discuss and sign consents to evaluations. If the parent does so, they should simultaneously write to the principal or superintendent to delay any suspension process and to immediately return the student to school with appropriate supports pending the child study team process. Well, the first thing I would recommend a parent do when notice is received about a suspension on the same day of the incident or as soon as they receive it, is to write to a principal and or superintendent and request a meeting to discuss the reasons the student was suspended and whether returning the student to school immediately is appropriate. At this time, a parent can also request an alternative to suspension based upon the student record and all the circumstances. A parent should consider contacting an education attorney or advocate to get information and advocacy assistance either before or after reaching out to school staff to appeal a decision. Students have the right to appeal a short or long-term suspension at a board hearing, and school districts have to explain these rights in the Student Code of Conduct. For a short-term suspension, the district must allow the student to appeal a decision to the superintendent and then to the Board of Education. For a long-term suspension, the Board of Education hearing must take place within 30 days of the suspension. And it's important to remember that the parent may appeal a suspension if the school staff fail to comply with notice requirements and other procedures required by New Jersey law and school policies, which I talked about in the previous slides. When your child has been suspended or the school proposes a short or long-term suspension, and if the school refuses to immediately return the student to school after the parent and student present their perspective and concerns, parents should immediately write to the principal for copies of the incident report and all formal notices if they've not been provided. In addition, this letter should include a request for all records regarding behavior, discipline, attendance, written plans for intervention services and academics for all years the student has attended the particular school. The reason for this is that the parent needs to understand if this is an isolated incident or a pattern to see clearly what the school has tried to do to help their child. If the school staff knew from the student's history that the student needed help, and if they did try to provide supports, did they try other interventions if certain supports didn't lead to a change in behavior? The parent needs to understand, did the school try to get the parents' input? This information can all be used to defend a student who the administrator wants to suspend. Parents should also review the Student Code of Conduct and relevant school board policies regarding conduct and consequences. The reason for this is that school staff make mistakes and sometimes they don't follow their own rules. And when this happens and they suspend a student, this parent, if they challenge the suspension based on the fact that the school didn't follow their own rules, should result in the student being returned to school. After a board hearing, the parent will receive a written determination from the board within 5 days, which should include the charges and summary of evidence considered, factual findings and determinations regarding each charge, what education services will be provided during the suspension, the terms and condition of the suspension, and information about the right to appeal the board decision, including the right to appeal to the Commissioner of Education within 90 days. The board decision can be appealed to the Commissioner of Education if a parent believes that the district used discriminatory practices in suspending their child. A parent can also contact the Office of Civil Rights in New Jersey for assistance. The Office of Civil Rights has an intake process and will investigate a school if there is sufficient evidence of a discrimination-based claim. For students with IEPs, at any time after suspension, a parent could file for due process and request emergent relief from an administrative law judge. A suspension is one of the reasons that an administrative law judge will consider a request for emergency relief, which the request would be to return the student to school immediately, pending the resolution of the due process petition, which would be based upon an allegation that the suspension was inappropriate. These emergency requests for relief will be considered by a judge in a matter of days. However, with any method of appeal, it is again advisable to consult with an education attorney, as the laws and procedures are complicated. Finally, parents, adult students can always seek to appeal a record. This is helpful to know about whether for a short or long-term suspension. With a short-term suspension, while the student may be back in school in a few days, a parent may wish to write to the superintendent to get something removed from the record rather than go to a formal board hearing. The request to remove a suspension from a school record should seek to remove inaccurate, irrelevant, or improper information. If the superintendent refuses to remove something from the record, the parent or adult student can write to the superintendent to request to add information to the record, including reasonable comments or a statement that explains and or clarifies something in the record. A request can also include that the record not be shared with anyone or any outside institution or agency pending a determination of an appeal. Now, to appeal a record, the parent must write to the superintendent and explain the basis for the request. The superintendent must respond within 10 school days, and if not in agreement, the superintendent should meet with the parent to try to resolve the issues. The superintendent's decision on the record may be appealed to the Board of Education within 10 days and then to the Commissioner of Education. Regardless of the outcome, a parent is always permitted to add a statement to the record. And here I've included some helpful resources. And I hope you found this presentation helpful. And for further assistance, feel free to contact me at ACNJ. Thank you for attending.